Hello, everybody. I'm Sam Albrecht. I'm the Director of the Office of Regulatory Oversight. I am also uh, staff liaison and appointee to the Mobile Home Taxation Task Force, which is what we're here for today. We've only got an hour, so we're going to jump right into it. We've got at least three topics of discussion to cover and a short timeline. I will remind everybody that our deadline to get the report to the legislature is the 1st of October. We have two meetings after this to get that task accomplished. With that, I'm going to share my screen real quick. Can everybody see that screen okay?
Yes.
Okay, fantastic. When I go to share screen, since I'm not a Zoom expert, I lose everybody's pictures, and so if I ask you a question, I might need a verbal response. But today's the task force meeting. Our agenda today is kind of just again talk about the guidelines and overview and scope. Then we'll go into Bridget's going to talk about current mobile home tax lien and owner transfer process. We'll talk a little bit if Jack's on the line about homeowner concerns. And then wrap it up with a statutory review from the attorney's office. And then I'll give you some staff updates. We'll look at the schedule for the next couple of meetings, and then we will wrap up this meeting. So with that said, just guidelines and overview and scope. Since we do only have an hour, this task force is a 15-person task force, so there's a lot of variance in opinions and positions. We want to make sure task force members have priority in speaking. Guests are welcome. We appreciate your input. If you have something you would like to say, if we have time, you can raise your hand or type a comment into the chat, and we will get to you as quickly as we can. As I expect, running these type of meetings, we will have new people pop in and out on not only this meeting, but a couple of the other meetings. This task force is primarily and only, actually, I won't say primarily, is only dealing with Senate Bill 24-183, the Mobile Home Ownership and Taxation Task Force. Our tasks are primarily to take a look at a U.S. Supreme Court decision that talked about Fifth Amendment rights during the distraint sales of mobile homes, and what statutory changes we might need to make in order to correct that. And in addition to that, there are some other tasks where we ask about potential other legislative changes, but the primary task is that U.S. Supreme Court decision. And with that said, and then there's also a task on a potential scope of work for a new computer program for mobile home taxation and mobile home titles. And that group is also meeting on a regular basis, and I will provide an update on that during staff reports. With that, I'm going to just turn it back over to Bridget. She's going to start us off with current mobile home tax lien and owner transfer process.
Okay, I'll go ahead and share my screen as well. Are you able to see the first page?
Yes, ma'am.
Yes. Does it say Mobile Home Task Force?
Yes, it does.
Okay. All right, very good. Are you seeing the side panels as well, or is it full screen?
We are seeing the side panel, so I didn't know if that was intentional or not.
That's really not intentional. Let's try this. How about that? Does that work?
Yes, ma'am.
Okay,
Yeah,
very
that
good.
looks good.
All right, so this was actually a harder task than I had originally thought it would be because because mobile homes actually go from one year to the next. So I did have to break this up a little bit. If it gets confusing, please, ask your questions at the end. But basically, I'm Bridget Grimm. I'm the Weld County Treasurer and Public Trustee. I wanted to share this slide because it's actually not my slide. It was done by the Pam Anderson, I believe is her name, in Larimer County, but I thought it was really powerful because it does show the agencies and entities that are involved in these in the mobile home space. And, you know, if you just look at this, it's a little bit overwhelming. I tried to put a flow chart in there, but it really would have made your head spin. But it gives you a sense of how complicated this mobile home space is. So why are mobile homes taxed as real estate? Well, this goes back to 1977 when there was a legislative declaration that stated that the previous method of taxing mobile homes with the SOT, specific ownership tax, was inappropriate. So the old method imposed a special fee on mobile homes that was not imposed on conventional homes. So starting January 1978, the mobile homes were subject to ad valorem tax under the provisions of Article 1 and 9 of this title, as if they were real property, but they shall be subject to the provisions of Article 10 of this title concerning the collection of property, collection of taxes as if they were personal property. This right here starts this is kind of the beginning of where things get tricky. So how are they assessed? Mobile homes are considered residential property, and so they're valued using market-only model and assessed at the residential rate. The county assessor uses documentation from the clerk to determine the taxable value. So is there a bright side to all of this? Many would say yes. Mobile homes are eligible for both senior citizen and disabled veteran tax exemption. That would not have been the case had they stayed in that prior model. More great news: as of a few years ago, any mobile home that was valued less than $28,000 in actual value, starting on January 1st of 2022, would be exempt from personal property tax. It was determined that this exemption really didn't have a huge impact on local government. And just from a Weld County perspective, we had like 6,500 mobile homes on the tax roll, and now we have less than half. So that gives you a sense of what that exemption did in terms of taxing these mobile homes. I also do want to say that I'm using mobile homes throughout this presentation, but really manufactured home is the new verbiage that should be used. But since we are a mobile home task force, I tried to keep it consistent to just reduce any confusion. So I think it's important to talk about the similarities between the collection of mobile home taxes and all other types of property. So mobile homes are collected in the exact same manner as any other property. One important thing to note, if you are not familiar with how this works, Colorado tax notices are billed in arrears. So when we send the tax notice out in January, that is for 2023. So the tax notice that went out in January of 2024 was for 2023. So we collect the year after. The deadline dates are the same, payment requirements are the same, tax lien sale, all of that's the same. Mobile homes are valued on the market approach or sales of other manufactured home as of the appraisal date. That's all consistent. And mobile home owners receive a NOV, notice of valuation, just like other properties. So those are the similarities. We have two primary differences. The first one is advertising. The advertising dates for mobile homes before a tax lien sale. Now, tax lien sale usually happens in very late October, but most of the time in November. So the advertising dates before tax lien sale are different than real property. The advertising dates for mobile homes on leased land. So for example, if it's a mobile home sitting in a mobile home park, are the same as the personal property. And so during the month of September, the treasurer shall publish for one time only. That's the difference. It's one time. Real property is 3 times. Such notice shall recite the amount of the delinquent tax. Now, this is really, there's some play in here for counties. Some counties do it differently. In Weld County, we actually do publish any delinquent mobile home tax right along with real property. So we give 2 additional notices. So you will see delinquent mobile home tax published 3 times, but we don't pass the fee on. So we only pass the statutory fee for the one required, but we add 2 additional. And I do want to say that you will see this with many counties going above and beyond the minimum statutory requirements to make sure that the mobile home communities have as much awareness of any delinquent tax. Another really big difference is the redemption period. I know this is the one that comes up a lot. Mobile homes located on leased land. So remember, that's if the landowner is not the mobile home owner. So a mobile home located on leased land or any other land not owned by the owner of the mobile home may be redeemed by the owner within 1 year after the date of sale. So they've got 12 months to get the delinquent taxes paid. Mobile home that's located on land owned by the owner of the mobile home. So you own the land and you own the mobile home on the land. You have 3 years after the date of sale, after the tax lien sale. This was an interesting one because I spoke with a handful of counties and not entirely sure everybody does it that way, but there is generally an attempt to there's a lot of outreach. So these ones that have the mobile home land and the mobile home in the same name, they're generally flagged differently. The other thing I want to mention is that there are a number of treasurer softwares in the state of Colorado. So not all software does the same thing in terms of flagging or anything, actually. So I put this calendar on here. The hard part about this calendar is this kind of captures our collection year, January through December. Because we bill in arrears, when tax liens roll over to the next year, there's a different process. So I'm going to try and capture the whole thing, but it is complicated in the sense that you can't put the slides together because it becomes confusing. So when you look at this slide, January through July there is no difference between mobile home and real property, real meaning a statutory word for the other property. After the 3 statutory deadlines of February, actually end of April, and then June 15th, in July, we send out the delinquent notices. September, we start the advertising. There's a $10 advertising fee that gets added to the delinquent tax. This is across the board. Middle of September, we advertise the mobile homes. Now, this is where the personal property piece kind of comes into play. We don't distrain real property, but we do distrain mobile homes. So no earlier than October 2nd, there is a $50 distraint fee added. The distraint is done it's done once in the first year. And then, as I mentioned, it rolls over to the next year. It's delinquent. The delinquency carries through. And then there's another distraint type process to, again, try to get a hold of everybody that we can before that 12-year or 12-month mark. So, and then the tax sale is the tax sale is in November, but in the case of the mobile homes, this is the time frame where the certificate owner can apply for ownership. So let's break into these months differently. July and August of the first year of delinquency, the second year of delinquency, the lien holder is allowed to endorse any delinquent taxes. So per statute, any person desiring to pay subsequent taxes may do so. And so letters are sent out to lien holders to let them know there are delinquent taxes, the second year taxes are not paid, and they can pay those taxes. What happens when they do that is that one lien that they had from the prior year plus the second plus the endorsement creates one bigger lien. So it's not two separate liens, it's one lien with 2 years. So in September, additional efforts are different counties do it differently, but beginning on the 1st of September, some counties post orange tags just to get their bright orange, just to get the attention of actually anybody to let them know that there's some delinquent tax due on the property. This method has been very effective in Larimer County. Some actually reach out to park owners to make sure they have the correct owner. So are they sending a tax notice to the previous owner because the title didn't get updated? There are many reasons why the new owner doesn't get the notice in their name. And these are actually efforts that most counties do, especially the counties with a large mobile home community. These efforts are considered a courtesy. They're not required by law. And really what we're trying to do is get the attention of the property owner, mobile home owner, so that we can avoid adding the $50 distraint fee. This is an example of what Larimer County does. Again, I'm using Larimer County. I worked there for 4 years, and it was so impressive to see the outreach that they do, because they do have a large community, and the numbers their efforts are reflected in the decline of mobile homes that are lost through this process. So kudos to them. They're doing an excellent job. And this is just one example. It's a little probably been updated since this version, but it gives you a sense of what they're doing. October is we're at the end now. We don't have a lot of time. So statute says that 30 days prior to the close of the redemption period, remember that's a 12-month period, the treasurer shall notify the owner of the mobile home and any lien holder. This can be mortgage companies, and a last effort to try to get these taxes paid. And they are mailed, certified mail, on the first part of October. So as I mentioned earlier, we do have counties that go above and beyond. Some go out again and do additional flagging, putting the orange tags or red tags or whatever it is on these mobile homes to get one final exposure to the delinquent tax. Now we're at the 12-month redemption period. It's expired, and the lien holder, the tax lien holder, now can come into our office and request a certificate of ownership. And with that ownership, there are some additional fees that come with that, redemption fees. Some of that is rolled. Each county probably looks a little different, but bottom line, there are some additional fees. And then, of course, there's some credentialing that's done to make sure that this person is authorized to request this certificate of ownership. This is a just a picture. I don't know if you can see it. It's just really a sample of a certificate of ownership. So this is what it looks like. This certificate of ownership will then be taken to the clerk, and they will get that ownership changed over. But it does have all the information on there: VIN number, the make, the year, the size, name, property address, even the tax schedule. I put this slide in here because there are some additional laws that say, hey, if you are a mobile homeowner, there are some requirements that you, notify the correct authority of when you apply or when you purchase a new mobile home or even a used mobile home. So it says the buyer must apply for a new title within 45 days of a new manufactured home, mobile home, or 30 days from the sale of a used mobile home. This is probably, because it's so hard to enforce these, this is probably one of our greatest pain points. At least I'm speaking from a treasurer perspective, is a lot of times we're trying to reach the wrong person for these taxes. And so when these can't really be enforced, it's difficult to know who the right owner is. Now, I wanted to add a couple additional slides. Where am I at on time?
You've got a couple minutes.
Okay. So I mentioned, let's go back to January of 2023. Okay. So that's the 22 taxes collected in 23. We do the same collection efforts from January through June. July, we do the delinquents. There is nothing to endorse because it's a brand new delinquency. It's a first time delinquency. So there's no lien holder involved yet. So there are these attempts to reach out to these property owners before it even goes to tax lien. So in September, we're reaching out to the clerk actually to see if there are any lien holders, mortgage companies mostly, that we can reach out to and say, hey, there are some delinquent taxes on this property that you have a lien on. So that's the effort we're doing in that 2023 September timeframe. In October, we do distrain these properties. So that's when the first distraint happens. There really isn't another distraint in October of 2024, but there are those additional steps that are being done in October of 2024 that kind of look like the distraint, right? They're that notice that gets put on the door. But this is statute says that we have to distrain these properties. So the first day of October, anytime after the first day of October, the treasurer may enforce collection of delinquent taxes by distraining, seizing, and selling. I've worked in 3 counties now in the treasurer's office, and we have never sold the mobile homes based on this statute. So we distrain them and take them to tax sale. Whenever a distraint issue is warrant, it shall be served by a sheriff or a commissioned deputy. So different counties do that differently. They are not distrained in the second year. That's when those extra efforts are done. November is the first tax. That's the tax lien. So they go to tax lien. We have live and online auctions throughout the state. Some counties hold separate mobile home tax lien sales, separate from real property. In many cases now, it appears mobile home accounts are taken to tax sale, but then they're struck to the county. So what that means is the county ends up being the lien holder, and then the county does not pay the taxes on these properties. But so basically they just hold the lien, and if the owner is found later, then the county can assign that lien to the rightful owner. So in closing, Really, I think we're trying to say that communication is crucial with other county offices. This is a very complex model that involves the assessor, the clerk and recorder, and the treasurer, and we all have to be talking to each other, as I showed you on that first slide. Sharing information on the changes of manufactured homes is very, very helpful for the treasurer when we are trying to collect these taxes. And then mobile home issues can be very unique, which is why you see a number of different ways they are counties add value in the collection effort. And that's what I've got.
Thank you, Bridget. That was very informative. I actually learned a few things, so thank you. Any quick questions for Bridget before we go to the next presentation?
I have a quick question. When you say, let's see, the delinquent home is advertised. I'm curious, what is advertised? Is it just that they are delinquent? Is that there
Yeah, that's a
is
really
a
very great
lien
question. Yeah,
up for
statute
sale,
is,
or what's just hoping to get clarity on that.
yeah. It's actually advertised in the paper. So we are required to I think there are at least 3 fields that are required. It's the account number, the name, and the amount delinquent. So with all other properties, we advertise 3 times by statute. In Weld County, and I actually think maybe in Larimer County, if I remember correctly, we add the mobile homes to that list. So we always want to give as much visibility to any delinquent balances. So we add the mobile homes to the 3 published in the paper notifications.
Okay, so that's just for the delinquency itself. It sounds like, and then the other part I was wondering about is that it sounds like there's also a separate period when the liens are sold. There's a sale of the liens potentially, and I missed the difference between the two and when
Yeah,
the sale of the liens might happen.
Yeah, so the lien is sold at tax sale on the first year. So I primarily focused on 2024, but that lien that I focused on for 2024 actually happened in November of last year. So the lien, not the property, but the lien on the property goes to tax sale. And in theory, anybody can be an investor, sign up to be an investor, and then they can, depending on the style of the auction, they can highest bid wins the lien. So they own the lien. So they still don't have any rights to the property. And then the property owner now has, in the case of mobile home and landowner are different. The mobile home owner now has 1 year to pay the delinquent taxes. So when those taxes, so if the homeowner comes in and says, here's my delinquent tax, then what we do in the treasurer's office is pay the investor. Investor comes out of that equation, and now there is no lien on that property. And we start over for the next year.
So you said that some of them get struck to the county, and so how many liens are actually purchased versus how many do the county end up absorbing?
Yeah, so this is a great question because it's not, there's no requirement to strike them to the county, but I've been working in the treasurer's world for close to 14 years, and we've been doing this for a long time. So we stopped. What we did is we actually struck them to the county. So now the county is the lien holder, and really what that does is it buys the mobile homeowner some more time because we, the county, are not going to take ownership. And that gives us a little extra time to continue to reach out to these mobile home parks to try to find the owner of the property in the event that's the case. Sometimes it is a property owner didn't pay their taxes. That is absolutely possible. But we do have a lot of accounts where the owner of record isn't who owns the property based on a subsequent transaction. So somebody else buys the home, but the title never got changed. So we have a name on an account that may be the name of someone who sold it to somebody else. So really what we do with that extra time is we spend it trying to work with mobile home parks, trying to find who do they have on their lease? Is that the same person that we have as the owner of the property? So it's a collaborative effort, and everybody does it differently. Every county does it differently. So when I say in most counties, I'm talking about in Larimer, in Adams, and in Weld, we would strike the mobile homes to the county. So the county ends up being the lien holder. Does that help?
I have more questions, but I don't. I know there's an agenda here, so
Okay.
maybe I'll email you a couple
Okay.
of other questions I have.
All right, thank you, everybody. Jack, did you want to touch base on some of the homeowner concerns that you were alluding to in the last meeting?
Thank you, Sam, and thank you, Bridget, for that really interesting and informative presentation. And good afternoon, everyone. I'm Jack Reagan-Bogan. Again, I'm the Deputy Director at Colorado Poverty Law Project, and we're a nonprofit that serves renters and mobile homeowners through free legal assistance. We also provide housing navigation and advocacy. I'll try to keep this fairly concise in the interest of time, but I did want to explain how we've been engaging on these issues and what we might hope to see come from this task force, or at least hope to see considered.
Jack, do you have a presentation, or are you just talking? I'll have Bridget stop sharing.
Oh, I'm just talking. I don't
Okay.
have a PowerPoint.
Bridget, do you mind stop sharing? There we go. Thank you.
So, we are big supporters of mobile home ownership because we believe it's a relatively affordable means to attain home ownership, particularly in the unsubsidized market and as compared to site-built housing. And so to that end, philosophically, our goal is to largely align the same rights and redemption processes for mobile homeowners as those that are afforded to other types of real property owners. And as a matter of fairness, as a matter of equity, we don't quite agree with or understand why mobile homeowners uniquely are subject to paying the ad valorem taxes, but are only entitled to the rights that are afforded under the personal property tax collection process. So in the wake of Tyler v. Hennepin, some of you may already know this, but the first iteration of legislation to address that issue wasn't Senate Bill 183, it was Senate Bill 97. And that bill, as drafted, really just did two things. It would have solved the Hennepin issue by ensuring that any proceeds from the tax sale would go back to the original owner. And it also would have increased the redemption period, not from 1 year to 3 years like other homeowners, but from 1 year to 2 years. We thought this was a pretty good start, but this still left some concerns about inequities and disparities with other types of homeowners. In fact, I think the Attorney General's office, which produced a memorandum after Tyler v. Hennepin, did a nice job of summarizing what those disparities are. And so what I'm going to do is just real quickly put in the chat here. I'm copying and pasting an excerpt from that Attorney General memorandum. And so in light of these disparities, and they talk about the 1 year versus 3 year to redeem, for other types of real property owners, if they have a legal disability, they actually get 9 years to redeem, but that doesn't apply to mobile homeowners. Then there's some confusion, I think, as to whether the mobile homeowner is obligated to pay the tax debt plus interest Or do they actually have to pay the entire auction price if there was a profit? I've had at least one conversation with a county treasurer where they've told me they only ask the mobile homeowner to pay the tax debt plus the fees and the interest. They don't ask for the profits. But when I did a plain reading of what's in CRS 3910 11.111.5 subsection 6, it does say that they're responsible for paying back the proceeds of the tax sale. So depending on how that's being applied, that would seem to be a major disparity insofar as the mobile homeowner has to pay not just the tax debt, but the full profit, any profit on the auction in order to redeem. We also asked the sponsors of this legislation if they might consider formalizing and institutionalizing some of these really great outreach efforts that we understand some counties are already doing, but may not be uniform across the state. And in particular, we emphasize the need for bilingual outreach. So any correspondence that goes out, ensuring that it's in both English and in Spanish, and also wanting really ideally to have an insert in 8 to 10 of the most commonly spoken languages in that county, even if it's just a sentence or two that says, if you have questions, here's a number you can call and get your questions answered. So those were originally kind of our main concerns and our main policy suggestions, was increasing the redemption period from 1 year to 3 years, 9 years for a person with a legal disability, clarifying that to redeem, the homeowner only has to pay the tax debt and the interest. We can talk about some of these fees, but not the full auction price. And then codifying robust multilingual access or outreach. Two other things that I'll mention briefly, and I did include these in our responses to the survey that was sent out, is there was reference to that bill a few years ago. I think it was Representative Kathy Kipp who sponsored that legislation, exempting from all property taxes mobile homes with an actual value of $28,000 or less. And Bridget described how that has had a de minimis impact on collection amounts. We supported that legislation. However, the $28,000 was not pegged to increase with inflation. To my knowledge, there's no index. I actually think that we think that amount could immediately be set at a higher threshold, and that regardless, it should be indexed to increase with inflation, because part of the logic is the return on investment for counties, and as costs go up and their staff salaries go up, that return on investment calculation is going to look different. But the $28,000 as of right now is fixed. And then the very last thing, and then I'll conclude because I know we're running a little short on time. And this might be a little outside the scope of this task force, but maybe it's not. And the reason it will be outside the scope is because this deals with the taxation of mobile home parks, not just individual mobile homes. But some of you might be aware of a legislative effort a few years ago that exempted community land trusts that are held by charitable nonprofit organizations and that are maintained as low-income affordable housing. The way that community land trust has been interpreted by the Department of Revenue is that it excludes nonprofit-owned mobile home parks. Now, there aren't that many in Colorado. To my knowledge, there may only be one or two mobile home parks that are held by nonprofits as affordable housing. But we've heard from at least one of them, and they've voiced concerns that their property tax liability, I think, tripled in a year, and it was causing a big strain on their operating cost. And so one other goal that I just wanted to mention for consideration is the idea of expanding on this legislation. It was House Bill 23-1184 that exempted community land trust, and we would hope to add nonprofit held mobile home parks to that list of property tax exemptions.
Jack, would that include, I'm sorry, did I interrupt you?
No, please.
Would that include co-ops, owner co-ops would be exempt from property tax?
Under the current law or under what we would like to see?
What you would like to see?
I think what we would like to see, not necessarily. I think we would have a pretty narrow definition of mobile home parks that are held by 501c3s, which may or may not be set up as a co-op, and that
Right.
are maintained with a subsidized housing. So that there would have to be some sort of subsidy component for the residents.
Yeah, we are starting to see a few more co-ops buy properties. We're also starting to see local governments buy properties, but I'm pretty sure they exempt themselves from sales tax or property tax. Sorry.
Jack, I did want to address two things that I remembered you spoke about, but the notifications that go out, we actually put all three counties, Adams, Weld, and Larimer, and I suspect most counties do have another insert that's in Spanish. So, or the primary second language that we see in Weld County. So we do that. And then the other one was that I think what you're talking about is the premium. So like if the delinquent tax is $100 and an investor says I'll give $110, that premium, they don't get, the investor does not get that premium back. That's above and beyond what we're asking for. So I'm not sure if that's the amount that you're talking about. There is when you do online auctions, I think there's well, I know there is, I just don't know how much it is. To have an online auction, I want to say like either $10 or $30, something like that. But that is rolled up into what the investor pays. So the investor pays all the cost of that property to go to sale, but the homeowner does not pay the premium.
Can I ask,
That mhm.
what I'm getting tripped up on, and I just put it in the chat, is when I was learning about this topic and I looked at 3910 111.56a, it says here that when it's mobile home that's on leased land, that this is the owner thereof may be redeemed by the owner thereof within 1 year after the date of the sale upon payment to the treasurer of the proceeds of the sale, interest on the amount. So it says proceeds of the sale. Would that not include the premium?
Yeah, I need to, no, I don't think it does. But I'm making note of it to check that. That is a very interesting word, proceeds of the sale. I think it really means taxes and interest, and any statutory fees that are required to be put on there, distraint fees. So those, I believe, might be considered the proceeds of the sale, but the premium, I don't believe I will double check. I'll know by the end of the day. I'll know within an hour. I don't believe they're paying the premium. That's the added risk an investor is willing to take based on some math that they do. So not all properties have premiums. I suspect mobile homes especially don't have a lot of premiums on them. But I'll find out.
All right, we've got three other hands up. Thank you, Bridget. Mike, I'm going to go in the order that I see them. Michael?
Thanks. Was just really curious about I want to give a big thumbs up to expanding our recommendations to include mobile parks and taxes for them. But was just very curious about the reason for limiting that to 501c3s versus the Rock USA style of co-op, where the strictures for Rock USA co-ops really prohibit any kind of profits from anybody within the park. The park sales are the sale of the park is limited to being sold to a nonprofit. No proceeds of the sale can be accrued by any of the homeowners or members of the co-op. So there's all kinds of strictures that make the Rock USA style co-ops very much like 501c3s, except that they fall just a little bit short of the IRS requirements for being a 501c3. So I'm just very curious if there's a reason for not extending that to the co-ops.
No, a great question. I would be very open to that. Yeah, I think philosophically, what we're trying to capture is that when a park is being maintained, not for shareholder profit, but for a public interest motivation, and there's some degree of cost control, whether that be through the 501(c)(3) nonprofit structure or through a self-governance structure, that's a unique circumstances that would warrant a departure from typical property tax liability. But I would be open to that, what you're suggesting.
Thank you.
Thanks.
I'm going to go to Commissioner Vanderwerf.
Yes, thank you very much, Sam. I appreciate it. And my apologies for not being at last month's meeting, which I believe was the first meeting, but I was appointed to this board and just could not make that. But here I am. I'm one of the commissioners for El Paso County, Colorado, the county that's got Colorado Springs in it. I wanted to just kind of bring up 2 points. The first one is, you may have discussed it in the last meeting, so my apologies for missing it. Are tiny homes included in this discussion?
Yes,
And I'll tell
tiny
you why
home.
I'm asking the question, because in 2017, El Paso County developed an entire section of land use policy for tiny homes, where tiny homes can be used and treated like RVs in RV parks, but also get used and treated like mobile homes when they're in mobile home parks, and that you can mix and match RVs and tiny homes and mobile homes and tiny homes, depending on what kind of park you're in. Also, we did a lot of other things with regard to allowing tiny homes to be used as accessory dwelling units and things like that. So the first question from me is, are tiny homes part of this discussion or not? And then the second comment that I would like to make, and it's really more a comment, but whatever we do, there's certainly, I think it's clear to everybody here, there's complexity in the law associated with the use of mobile homes. We see it where we're having conversations about it. We're all learning something about that law as we're going along. Whatever we do, we really need to think hard about how to make this simple. Simple for the consumer, simple for compliance, simple for state implementation. We need to make it as simple as we possibly can, because state law in Colorado is getting more complex and it's getting harder, and that's producing regulatory burden, and we really need to pay some attention to that. So I don't know how easy that'll be to deal with, but we really need to pay attention about trying our best to make this simple. So thank you. The question for the floor right now, though, is, are tiny homes included?
Yes, so I am the tiny home guy for the state of Colorado. So yes, tiny homes, when they're meet the definition of a mobile home, that they're designed for long-term occupancy, and in a mobile home park, then they will qualify as a mobile home within that park. If they are not designed for long-term occupancy, which means if they are an RV, then that doesn't mean that they are built to the building standards for long-term occupancy, and therefore I do not believe that they would qualify under the Mobile Home Park Act. I can get more clarification on that. We do have a state certified tiny home now that can be built to the IRC standard, and if it goes in, and it can go on a temporary or permanent foundation or go into an RV park. So there's 3 different possibilities of attachment to the ground for those units. So yes, we are going to include that. The complexity of the law, commissioners, yes. Things are extremely complex, but I want to go to Dan Hunt, and then I want to get to our attorneys pretty quick. Dan?
Hi, I'm glad to be here. Thanks for all the work everybody's doing. A couple of comments along Jack's talk is that I live in a rock-styled mobile home park, and so we're a cooperative, and by state law, cooperatives are actually not nonprofits, but they're not-for-profit. And so I've seen that open us up to funding areas that we wouldn't have been able to access otherwise. The other thing I wanted to mention too is that I met with my county assessor last week to talk about how we can deal with the huge rises in property taxes that we've had. And I found in one of our loan documents a covenant that said, like what Michael said, that we could we could not benefit profit-wise. Shit. Oh, sorry. So she actually froze our assessment due to that. And so I just wanted to be sure people knew that that was something that might be happening out there. And then I think I'd like to see that whatever those processes are, that they're standardized across the state. Thank you.
Okay, thank you, Dan. I appreciate that. I want to call on our attorneys now, Harlan Norby and Robert Dodd, to kind of discuss the primary purpose of this, and that was that U.S. Supreme Court decision, the AG's opinion letter, and I gave them some statutory references, kind of the homework too. I gave them this homework a little late, so let's see what they got. Harlan, are you speaking or is Robert speaking?
I'll start here.
Okay,
Absolutely.
cool. Great. Thank you.
So I'll start with Tyler, and I do want to be mindful of our time, so I'm going to kind of parse down what I was going to talk about. But Tyler's really the United States Supreme Court case that started all of this for us. That case dealt with the collection in Minnesota, in a Minnesota county, of property taxes, I believe for a condominium that Miss Tyler owned. So in Minnesota, they had a fairly similar property tax scheme to what Colorado had. The biggest difference between theirs and Colorado's is that Minnesota's system allowed the state government to take the property earlier than Colorado's system does. They got limited title after a year, whereas in Colorado, there's that 3-year waiting period before anybody can obtain title under the property tax or the property statutory lien system. But otherwise, for purposes of Tyler, Colorado's and Minnesota's legal system is very similar. So in that case, basically, Miss Tyler owed about $2,300 in unpaid property taxes for her condominium. And then over a course of a few years, she got about $13,000 in fees and late penalties. So her total tax bill came to about $15,000. The state, under the property tax system there, the property deed system, excuse me, took title to her property and sold her condominium for about $40,000. So, there's about $25,000 profit there in that sale. Under Minnesota's property tax system, Minnesota was able to keep that. And when I say Minnesota, I'm talking about the county here, Hennepin County, but the county was able to retain that money. So basically the case wound its way up through all the court systems and got to the U.S. Supreme Court. And the U.S. Supreme Court held that the Hennepin County's keeping or retaining of that $25,000 was an unconstitutional taking under the United States Fifth Amendment to the Constitution. And basically what they're saying there is under that constitutional provision, the government can take personal property, it can take real property, but when it takes property, it has to give just compensation for that. And so, in their analysis, they kind of took a historical view of what takings look like. And they said, no matter what, under any kind of legal system that, was baked into our legal system, people were given the value of their property when it was taken. So a couple big takeaways from Tyler, I think they're important for us in this case here, is that the Supreme Court did not strike down those extra fees, did not strike down that extra money. It really didn't spend any analysis or any time on that. It basically said, kind of reading between the lines, that $15,000 tax debt, the state or the county could come after, but that they could not keep that $25,000 profit from the sale. Another big takeaway that we have from that is that opinion talks a lot about a case from, I think, 1920, New York, called Nelson. And in that case, there was the city of New York had a statute that allowed them to take title to property for unpaid water bills. And under that statutory scheme, the owner of the property didn't have a way to get their property back, but they had a way to get the value, the excess value from the sale back. That window was only 20 days. And the Supreme Court talked about that approvingly, as if that was not a taking then, because there was an opportunity for that homeowner to recover the excess value of the property. In the legal world, there's a lot of debate about whether or not that's dicta, which is kind of a term for extra stuff that a court says in a case that it doesn't need to say. So there's a lot of debate back there, but Tyler was a 9-0 opinion, which I think tells us a lot right now in our current framework, or in the current federal framework. And they did cite and spend a lot of time talking about that case. So there is a likelihood that if that gets tested out, or when that gets tested out here in the future, that the Supreme Court will kind of follow suit with what it's doing right now. The last takeaway I think we have from that case is Tyler finishes by talking about abandonment, and that it didn't change the legal framework for abandonment. So that if a mobile home is abandoned, the state can come and take title to that mobile home, without providing just compensation. So I am happy to answer any questions about that. I see our time though, so I do want to be wary of that.
And thank you for being respectful of our time, and hopefully we only go a couple minutes over here. Have you guys had a chance yet to look at current statute to see how Tyler and the AG opinion letter should be? Are there big red flags in the current statute that came to your mind?
The biggest red flag comes in 3910 111.5. And that is directly referenced in Senate Bill 183. And that's where the language was changed in 2A that says, and let me quote the language so that I don't butcher that. They added in, I think, before the effective date of Senate Bill 24-183, which basically says that it puts kind of a stop on the sale and the destroying process of mobile homes right now. So that's the biggest deal that we see right now with it, and that's what needs to immediately be changed. I think we need to do a little bit more work digging into the entire statutory scheme to see where else there's implications of that, because there definitely are. But the low hanging fruit, I guess, is right there in 3910 111.5.
Yeah, it does say stop the distraint sale, but and then Senate Bill 183 also says fix the statute. And so that's what I'm struggling with to get done in a month.
Right. Absolutely. And I mean, I think there's multiple ways to do that. So I think that's where Robert and I don't want to put a heavy hand on the task force here and say, do what we're telling you to do, because that's
and I appreciate that. And I don't want to put you guys in an uncomfortable position at all.
Absolutely.
Yeah.
Yeah. I mean, I think the biggest thing is that there needs to be an avenue for homeowners to recover whatever the excess value of their property is. I think there's lots of different ways to do that. I think there are other concerns beyond that, such as what Mr. Regenbogen said there. I mean, there are other things that are kind of implicated in all of this, such as the redemption period and the notice periods.
Sure.
The key takeaway of all of that is some sort of way for the homeowner to have an opportunity to get the money back. And I think there's a lot of discretion there with what that looks like. I mean, it could be an opportunity that a homeowner gets the money no matter what. It could be a level of time. So, but there needs to be some sort of mechanism where that money doesn't automatically go to the county's general fund.
There's been some really good discussion in the chat, and so we will try to post the chat too. I don't think there's any problem with that when we go forward. I just clicked on Senate Bill 24097 because it does look like they tried to fix that there, so that there may be some draft language already available for us to use. I just want to give an update also that we are continuing to work on the OIT project, the website. Michelle, do me a favor, throw up the website link or web page link. It has the statute, it has the AG opinion letter, and it has Tyler versus which county? Some county in Minnesota. And so all that is there, as well as the previous information from the previous recording from the other meetings. So with that said, I know we are 3 minutes past. I want to thank everybody here. I'll be around for a few more minutes if we want to have some more discussion, and I'll keep the recording going until almost everybody drops off. But if you have a 2 o'clock, I apologize for running 3 minutes over, and we'll talk to you the first week of September. And staff is going to continue to do some work. Basically, the next steps are get some draft language up there that we can all look at. and two, get a draft report up there that everybody can look at. And then the second meeting in September, we will finalize that report because it's due the next week to the governor's office. So all these things that we talked about with respect to homeowners and taxes, property taxes on mobile home parks, that will be included in the report, the tiny home discussion too, and the complexity of the law. We will get all those things identified, but what I want and the way this works is if we have draft statutory language that needs to be changed, the Colorado legislative system has a way to do that and not charge the legislators and the representatives and the senators one of their 5 or 3 bills. So they will automatically do that, and that's why we have to meet that October 1st deadline on the statutory language change for the distract sale of mobile homes. And Bridget, you're the chair, and I kind of just ran over you the whole meeting. Do you have any words of wisdom?
No, I appreciate it. I did reach out to find out what the format of the meeting was, but it worked out great. No, we're great.
Okay.
Thank you.
Anybody else have any questions for anybody else that's here or any other discussion?
Maybe I just add one piece of information that might clear a little bit up. When we take that lien to sale, the property is not going to sale. So it's only the delinquent taxes
So
and interest, all of that.
That is
What's that?
That's a perfectly fantastic statement. So does the unit itself ever sell, or is it just the tax lien on the property?
So the way it transfers ownership is when the person that got the lien, the tax lien, they now have the lien holder on that property. If that property owner does not pay their delinquent tax, and by the way, it does not include the premium if there is one. So it's just tax and interest and whatever statutory fees can be added for publishing, different things like that. The property owner pays that amount within the 12 months. Then it's all done. The investor is out of the picture. He's been paid in full. If he paid a premium, he does not get that back, but the property owner does not pay that premium. So that premium is what goes to the county. So the property never transferred. However, if the property owner does not pay their taxes in that 12-month period, then the lien holder has the ability to come into the treasurer's office and request a certificate of ownership.
And then the sheriff's office evicts them.
I don't know who evicts them. I've actually seen the lien holders show up knocking on the door telling people they own the property now. So
Okay.
I don't know what the formal eviction
They own the
process
property,
looks like.
but there is no excess sale of property. Harlan, are you hearing that?
I am hearing that. So I think, any kind of legal advice I would generally like to give in an executive session there. But yes, I am hearing that from you, Bridget. Thank you for that.
Okay.
Typically,
So the tax lien holder will get that property for the delinquent tax, plus the statutory fees and interest and all of that. So there are no overbid funds. We're not auctioning the property. We're literally handing ownership over based on the way mobile homes are handled, with the lien holder being allowed to apply for ownership of that property because it's a deed. It's a title, like a vehicle, right? That's kind of the challenge that we have they're treated differently because real property doesn't have a title. I mean, they've got deeds. It's a very different process, but it's literally They then go to the clerk and get a new title, like a car title with their name on it.
Yep. Okay, thank you. That helps me. Michael, you've got your hand up.
Sure. Just as a follow-up on that and the ability for the lien holder to go and apply for the title. I was just hoping for all of our edification, where in statute it is that provides that ability, just because it seems like whatever we do, we're going to need to reference that statute.
Are you asking about the statute that allows the tax lien holder to come in and request ownership
Yeah.
via a certificate of ownership? Yeah. You know what? I'll look at my presentation. I'm hoping I put it in there, but I can get that for you.
Any other questions or concerns?
The only
Sam,
thing
this
that-
is Tawny.
Oh, I'm
sorry,
sorry.
go ahead.
Hey,
No, no,
Tommy.
please, please.
Hey there. I was just wondering what do you need from us?
Me?
Yeah, like to keep things moving forward, to be prepared
Yeah.
for the next meeting. What do you need from us?
I need to determine if the current statute needs to be changed with respect to the distraint sale of mobile homes. But if we're not actually selling the unit and the property owner has a year, the owner has a year to pay the back taxes plus fees, is that still in violation of the U.S. Supreme Court? Harlan, that's my big question. And if it is, what in statute, says that, right? And needs changed. In addition, I need references for, we put in that survey, not references, but I need input on other things within the total mobile home title program between the assessors, the clerks, and the treasurers, and the interested parties, the park owners, the mobile home owners, on other potential changes in statute that to be considered in any future bill related to mobile home titles. I feel we are successful if we clear up the distraint sale piece of it. I feel we can go above being more than just successful if we identify other areas of concern that we would see come up that either clarify statute, simplify statute, and so every interest party has a voice here in this report, as they would when we see a draft piece of legislation coming forward. In addition, the OIT, Office of Information Technology, is doing that project on the overall mobile home title software scope of work. I won't have that done by the 1st of October, but that's so that may still require future legislation if we want to go to phase 2 of that project that somebody's going to have to sponsor. Tawny, does that kind of lay it all out?
It does. I just was curious to know if there was something that, I could do from my end with my members, etc., just, to provide you with anything. So I think that you've got the wheels turning in my head. And so
if there's something they don't like, and I shared that Google form that Michelle put together, and I was hoping that all the interested parties would get a chance to make any inputs on that. So Tawny, you can either gather input from your park owners and provide input, or share it with them and let them provide individual input.
Great. And that's and just to clarify, that's part of the web page for this group. Is that correct?
Yes, there is a button on the web page.
Okay.
But
And
I
thank you.
also mailed it to all the members of the task force.
Okay, because when I tried it earlier today to see if there was a public Zoom link, the page wasn't working.
Our page has been off and on today. Michelle, I
Okay.
think you said it's back up.
Yeah, I just clicked on it and it's not.
And just so
Okay.
you all know, Michelle just put that link for that shareholder input form on the chat.
Yeah.
Okay.
It was the same mobile home taxation task force link by mistake, and now it really is the link to the Google form.
So click on that link, Tawny, and everybody else, click on that link that'll should bypass the website. Nope, I get a temporary unavailable saying, so check back tomorrow. We'll
Okay.
send an email to everybody on the task force with that Google form. I've asked for deadline, a deadline of the 15th to get input back. So it's kind of tight, but there was an email last week also on that. Harlan, you were gonna have a final word, I think.
Yeah, the only other thing I was going to add is that the unconstitutional taking happens when title to the property transfers. It doesn't happen during the lien process. So that's something I don't think I clarified when I was discussing Tyler. So I think that everything we do here, we want to focus on the actual transfer of the title as opposed to the sale process.
Even though it doesn't affect that $25,000 sample or profit that you mentioned.
In terms of, I mean, the transfer happened, they're looking back at that point. I mean, they're looking at that's in the sale. They're determining the excess from the sale, but the actual taking occurs when the title transferred over to the new party. So they do look at the sale, but really they're just looking at value and
The
dollar
title
value.
transfers, but it's only because of delinquent taxes and fees. It's not because of there is no profit. There's no taking of the property. I mean, everybody has to pay taxes, I assume.
Yeah, taxes are not a taking.
Yeah.
So the taking is when the excess is kept during the transfer of property.
But there is no excess. It's all taxes and fees.
I think that depends. And I think to Mr. Regenbogen's point earlier, the statute is very unclear with what happens. And I think it depends on what counties are doing at this time.
Okay.
What that excess would look like.
We'll try to
and one additional, just one final thing. So with real property, obviously we're dealing with this as well because a deed could be transferred in the same fashion, but we are now required to take those to auction. So in this case, for real property, we are actually auctioning the property. So now there is a fair market value component that excess funds after the cost of taxes and all the fees, interest, all that, the excess overbid funds do go back to the property owner.
It does go
for
back.
Real property.
If you have a manufactured home on a piece of owned land, would that go to auction?
Don't know. That one, I don't know how that would work.
Okay.
Yeah.
Guys, I'm sorry. We've run over a little bit. We're 17
Thank you.
minutes over. I could do this all day, but I know I want to be respectful of your time. I'm going to stop the recording. Thank you all for coming. We'll have some emails out in the next few weeks to kind of get everybody ready for that next meeting.
Okay.
Please look for emails from me or Michelle because we are only got an hour. We only have an hour next meeting too. Thank you.
Okay. Thanks, guys. Bye.